I call Dennis O'Rourke.
Thank you, Mr Chairman. First of all, I'd like to comment on what the Honourable Trevor Mallard said in relation to Section 58, the validation of regularities, and I'd have to agree that this is an extraordinarily wide authority for the Governor-General to act on the advice of the Prime Minister, because if you look at the whole of Section 58, subsections 1, 2 and 3, you can see that just about anything could be authorised. And I thank the Honourable Trevor Mallard, because it's something that I hadn't realised during the Select Committee process, and I don't think others had either. And it certainly didn't go to the Regulations Review Committee. So I think this is a very valid concern. And I point out this, if you particularly look at 68.1, you see it says, in the circumstances described in subsection 2, the Governor-General may, by order in Council, do any of the things described in subsection 3. So then you look at subsection 2 and you find in clause E it says, if sufficient provision for something that needs to be done is not made or by or under this Act. Sufficient provision for something. Now that's about as wide as language can get, about as wide as it can get, and then you carry on and you look at... 3, yeah, even more. And you look at subsection 3 and you particularly look at D, which says, quote, to make such other provision for the case as the Governor-General thinks fit. Such other provision. I mean, how wide can a provision in an enactment get? So, in terms of validation of irregularities, we have an open door for the Prime Minister to tell the Governor-General to do just about anything in relation to this legislation. And I do think that it's going too far, and that provision should be struck out, and I'd invite the Minister to have a look at that and to take action on this before it goes any further. That is a serious issue. I'd also like to refer to Section 5A, the new Section 5A, which is set out on page 43. And if you look at that, it says in subsection 2, any person or body other than a government department may use the 1902 flag, except where required by law to use the New Zealand flag or another specified flag. Now, that's fair enough by itself, but then you go down a little bit further down the page and see in subsection 8, it talks about replacing section 10.2 and 3 with this. The Minister may, either in any notice issued under subsection 1 or otherwise, set out for the general information and guidance rules of conduct and the etiquette to be followed in the flying or use of any of the following: A, the New Zealand flag, B, the 1902 flag. So the Minister appears to be able to instruct how the 1902 flag will be used. So that doesn't sit well in my mind with the provisions of subsection 2 under 5A, which says that any person may use the 1902 flag. So what is it? Is there a freedom to use that flag, which of course doesn't need to be conveyed anyway, because I don't think there is any intention or any law against any person using any flag as they think fit. Nevertheless, there is this power for the Minister to dictate the etiquette to be followed in the flying of the 1902 flag. Why on earth is that there? Why is there any reference to the 1902 flag in that provision? It should be struck out, and I'd like the Minister to consider that before the matter goes any further as well. In fact, this whole section, I would say, actually results in general confusion, because I'm not sure when I read it whether the 1902 flag is still a New Zealand flag or not. It says that it is a flag of historical significance, but it says that it is a flag. What flag? What is its real status? This section doesn't really describe what the status of the 1902 flag is. As far as I'm concerned, I will use, when I need to, the 1902 flag but this provision is not good enough.